Hello, everyone. I want to talk today about AC21. There is a lot of mystery surrounding, a lot of mystique. People have been asking questions for a few years now, and it looks like I'm still not done answering all the questions. So I thought I'll just record this for you, and hopefully, I will cover most of the issues that I remember. When I made this presentation this morning in about 7 or 8 minutes, I think I covered everything, but in case I'm missing something, let me know. Of course, this is just the part one. I intend to do several parts on this AC21 issue. In the meantime, if you have any follow-up questions, something doesn't make sense, you are welcome to send us an email through the contact us form on immigration.com. Okay, immigration.com. So let's begin by talking about AC21. What exactly is AC21? This is an abbreviation for a law called American Competitiveness in the 21st Century Act. I think this law was enacted back in October 2000. So the law has been in effect for fully 12 years, and USCIS has still not given us regulations. That's very important for us to have regulations, because if we don't have regulations, we only have the bare bones of the law. In IT industry, you'll think of it as having just a high level design. We don't have any user interface. We don't have any functionality programmed. We don't have the code. We don't really know what the law will really look like in implementation. The last comprehensive interpretation of AC21 was back in May 2005 through something called the Yates Memorandum given by William Yates, which basically answered a lot of questions, but there's still a lot left unanswered. So what is AC21? It's a law that was enacted by Congress back in 2000. Okay. What is AC21's effect on H1? Basically, this allows you to get H1 extensions beyond 6 years. It allows you to change jobs while the H1 transfer is still pending. I'm not discussing that in this right now. I want to focus more on the green card side. And in the future videos that I want to do on this topic, I will bring you more information about how AC21 affects H1. What did I mess up here? Okay. AC21's effect on green card. First of all, what AC21 says is that every EB3, EB2, and some EB1 holders can change to a same or similar job as described in their green card. So whatever job was described in their green card, you can change to a same or similar job with any employer anywhere in USA. You are not geographically restricted. If your green card was filed for Colorado, you could move to California or Washington, D.C. That's perfectly okay. What is required is that the jobs be same or similar, your I-140 has been approved, and your 485 has been pending for 180 days. Okay, so first question is, how are the 180 days counted? That's an interesting count actually. A lot of people misunderstand that. The way it works is 180 days are counted based upon the pendency of the I-485, not necessarily after I-140 has been approved. Let me explain. Let's say I file your I-140 and 485 today. After 5 months, after 150 days, your I-140 gets approved. Now your 485 has been pending 150 days. We only need 30 more days to reach to that 180-day count. So in other words, we don't have to start counting from the date I-140 is actually approved. We do not. We count based upon how many days the I-485 itself was pending. So once the I-140 is approved, then by operation of law, we only count what is remaining of the 180 days. Once again, I file it today, both the I-140, 485. After 150 days, I-140 gets approved. Now I have to wait only 30 more days. I hope that is clear. What if I leave before the I-140 is approved? What if I leave before the I-140 is approved? So I'm working for an employer, and before my I-140 gets approved, I leave. What happens then? Well, Mr. Yates made that quite clear, that as long as the I-140 was approvable when filed, even if you left, it's not going to affect the merits of your AC21 claim. So once again, if the I-140 was approvable when filed, even if you left before the I-140 is approved, it's not going to hurt the merits of your I-140. But there's something you need to worry about for a second. Does the employer still have the intent to hire me back and I to rejoin? In other words, what triggers AC21? It is not the approval of I-140. Okay. What if my I-140 and 485 were not filed together, as it happens to a lot of people? Of course, if they were filed together, then remember the 150-day example I gave. Even if you left, the I-140 gets approved, we only have to wait those extra 30 days and we are comfortable in knowing that we are covered by AC21. Okay, but what if my I-140 has been filed but not my 485? Then I have to do this analysis. Does the employer still have the intention to hire me back and I to rejoin them? If so, when my priority date becomes current, I can file 485 based upon a letter given by the employer for whom I used to work. And Mr. Yates has made that clear as well. That, well, let me rephrase that. Not really in this context, but I would say that we are fairly safe. I'll come to the context Mr. Yates has made clear. Bill Yates said it's okay to do a 485 AC21 for a future job. Okay, I'll get to that in a second. I think it's there in my notes further. So if you leave before your I-140 is approved and before the 485 is filed, you've got to have a way to file a 485 through the employer who sponsored you, who initially filed for you, who petitioned for you. Okay, that means there must be an intention to hire and rejoin. Next point. Okay, I guess yeah. What if I leave before 180 days are over, but the I-140 is approved? Now the hypothetical is a little different. Remember the 150-day example. What if I leave on the 150th day? My I-140 is approved, but I'm still 30 days short of the 180 days that's needed for the 485 to be pending. This hypothetical assumes that both the I-140 and the 485 were concurrently filed. If they were not concurrently filed, then of course the previous analysis, the intent analysis, does the employer have the intent to hire me back? Then I can file a 485. Now remember, you can always carry the priority date forward. That's not what we are talking about. Once the I-140 is approved, your priority date can be carried forward. We are talking about AC21. That's a different section of the law and it's a different law altogether. Okay. So what if I leave on the 151st day? Am I okay? The answer is yes. You are okay as long as USCIS does not start questioning you on the 151st day. So, and Mr. Yates, Bill Yates said this. He says, if you have left before 180 days and you don't have an RFE response due back asking you about your job before the 180 days, you're okay. So if I got an RFE before I left and the RFE response is due before 180 days, then chances are I cannot use AC21. I can only carry forward my priority date. I know this is kind of complicated, guys, but I'm trying to make it as simple as I can. And if I'm not able to convey it, just listen and re-listen to the video until you get it. And if you don't, just join me in one of the free community conference calls, and I'll run over your scenario step by step and give you my answer about how I think your particular scenario would work. Okay, going back to what if I leave before 180 days are over, but the I-140 is approved. 485 is pending. I left on the 151st day. As long as an RFE response is not due before the 180 days, you're okay. Okay? So it's fairly safe to assume that you're going to be fine in any of these scenarios where you have left before the 180 days are over. Because typically the RFE itself gives you a few weeks to respond. And by that time, if you port it over, you can respond with a new job offer. Okay? What if I have left but I do not have a job for some time? Let's say you left on the 150th day, your I-140, 485 pending, I-140 approved, or even if both are pending. What if you don't have a job for some time? That's okay. Same analysis applies. As long as an RFE response is not due before the 180 days are over. If it is due before the 180 days are over, you could have some problems. But if it is not due, okay, you should be all right. And if you don't have a job for some time, that's okay too. May I port from a future job? This is a very interesting analysis, and Bill Yates' memorandum clearly says that yes. So I'm working for employer A on H1, and employer B has filed for my green card as a future job, or maybe even if I used to work with employer B and then I left them, but they continued my green card, it becomes a future job. Then I'm not working on that job. You can actually file I-140 as well as a 485 for a future job and still do an AC21 to any job. You actually never even have to join the future job as long as your intentions were clean when you filed the 485. So yes, you can port from a future job, and you can even port without ever joining that employer. May I port to my own company or business? This is a question I'm asked quite a lot, and the answer is yes. Bill Yates did not say that yes, it is allowed. He just said it is not forbidden. Double negative. Something like that. I have not read that memo for a while, but I remember reading that and thinking, why a double negative? And I'll tell you what I'm worried about. When somebody ports to their own company or business, one of the most important things is, remember I talked about same or similar? Jobs must be same or similar. This is where the problem occurs. Let's say your title was, I don't know, a biochemist or an IT engineer or a software engineer or a systems administrator. When you start your own company, you kind of become the CEO, right? You kind of become the manager. That's not acceptable. That could cause a problem. But what if you have a company that your wife is managing and you are just an employee? That's okay. That can be done. Okay. So when you port to your own company or business, make sure you discuss this in detail with your lawyers. Make sure you understand what you're allowed to do and what you're not allowed to do. Okay. That same or similar analysis is very confusing. Even to this day, we don't have clear understanding. So the closest you are to the jobs being same, you're better off you are. By the way, what do I mean by the same job? What if I was a Java developer in one job and a .NET developer in another job? I think that's okay. Now, this is my interpretation, because you're still a developer. Nowhere does the law says you must have, nowhere does the law say that you must have the same technologies covering both jobs. So in my view, you're okay even with different technologies. I've never had this view supported by the government. So consider it just my guess, something I would be comfortable arguing in court if I had to. Okay. A question that I'm asked quite often is, what do I have to do an AC21? What does it involve? Well, interesting thing is there is no law on what you are required to do. If you don't inform the government, you're not breaking any law. But it is in most cases, it's a smart idea to inform the government. Why? Because if you get an RFE, well, let me rephrase that. If you're, let's say you are now subject to AC21, you've ported over, and then the old employer goes and revokes the I-140. Now, for somebody who has successfully ported, that does not have any effect on them. Let them revoke. The old employer can revoke the I-140. You're still entitled to your AC21 benefits. Okay. However, I have seen cases where when an old employer revoked the I-140, instead of sending the usual RFE, USCIS sends a notice of intent to revoke the I-485. And if you don't get that in a timely manner, sometimes you can have an issue. Then you have to file a motion to reopen. It just becomes messy at that point of time. You may not have work authorization because your 485 has been revoked. And that's why I'm further down, I'm going to advise you also to keep your H1 active in most of these cases. Even though chances of something going wrong are extremely small, they do exist, and I like to cover every possible bad scenario that I possibly can. Okay? So what you have to do is basically have your lawyers write a letter to the government saying that I am using AC21 and porting over to a same or similar job. May I transfer more than once? Yes, you can do 20,000 change of employers. AC21 doesn't say you can only do it once. Okay. Should I keep my H1 active? I just spoke about that. I think you should as far as humanly possible. If for whatever reason you cannot, it's okay. I think you are still reasonably safe as long as you keep track of your EAD. But where possible, keep the H1 active. It's so much better for you. What are the dangers in using an AC21? One thing that has always bothered me is if for some reason your 485 is denied. For example, you are out of status, not even knowing that you are out of status, and your 485 gets denied, you lose your AC21. Now think about this. This is something I'm seeing come up, not frequently, but it does come up. An employee was placed in California where the LCA was approved for Colorado. That's a violation of the H1 laws. Most employers don't know that. Unfortunately, some of my colleagues, I've seen people being misadvised that you can just file a new LCA. That's not true. H1 amendments are needed when the move is beyond normal commuting distance. Okay? So inadvertently, you have fallen out of status for more than 180 days. Now, your 485 is deniable. You didn't know that. Next thing is you are getting a denial of your 485 and you are losing your right to AC21. Okay? That's one major danger that I see all the time. Other than that, everything is covered if you can keep an H1 active. And if you cannot, I feel that your risks are minimal. We have filed hundreds, if not thousands, of AC21 cases. I have not had a single case run into any kind of problem. Sometimes you can be interviewed. Does your risk of interview increase because you filed an AC21? I personally don't think so. I don't see any indication of that. But certainly I've heard people say that that's what happens. I don't feel that that's a major danger. I don't think that happens that frequently. But keep that in mind as well. Folks, I hope I was able to give you some useful information. I know it's kind of confusing, but we'll keep talking about it until things become clearer. Thank you for listening. Good luck.